to the zoning board of Highland Park. The meeting was called, yeah, right. The meeting was called to order in accordance with the Open Public Meetings Act. Noting this meeting was provided to the Home News Tribune, the Star Ledger, and the Highland Park Planet on March 24, 2026, and was posted on the borough website at www.highlandparkborough.com and on the bulletin board of the Borough Hall on 2021 South Fifth Avenue, Highland Park, and has remained continuously posted as required by law. The fire exits are to the left and to the right of the council chambers. And please, everybody speak into the microphone as the meeting is recorded. So, start with the allegiance to the flag. I pledge allegiance to the flag of the United States of America and to the republic which stands, one nation under God, indivisible, with liberty and justice for all. Thank you. The roll call, please.
Mr. Dickerson?
Here.
Mr. Fetcher?
Present.
Mr. Pheasant?
Present.
Mr. Hofer?
Present.
Mr. Holzapfel?
Present.
Ms. Corbett? Here. Ms. Leslie? Mr. Rothberg? Mr. Vining?
Here.
Ms. Walsh? Mr. Winfrey?
Here.
Mr. Gibbons?
Yes.
Mr. Cosenza?
Here.
Mr. Robinson?
Here.
Councilman Hale?
Here. Thank you. So, are there any comments, public comments, not related to the current matter of tonight? So we will be starting with hearing of a new case. That is the application number Z2602, which is a request for interpretation. And please allow me to say something about that, because in the 20 years that I have been a member of that zoning board Highland Park, I've never heard of that. Never, ever. And usually we hear applications for buildings, construction, something going on. This is about a notice for request for interpretation. And so I think for us as the board members, it's important to know it's not relevant if we think that this application is fulfilling zoning or requires a request for an exception of the existing zoning because it is approved by our zoning officer already. The question is the interpretation of the term accessory building. So I apologize, I'm a second language. I'm English my second language. So that's the topic at hand. I wanted to start for us as the board members to understand that it took me a while to get it because it's so unusual for us. So on that note, I would ask the applicants to present the case.
Mr. Chairman, before we begin, do I need to take
oh, yes, you do. Yes. Yes. Sorry for that.
Oh, good evening, sir. Would you be so kind as to raise your right hand and repeat after me? I, Nicholas Dickerson.
I, Nicholas Dickerson,
Do solemnly swear
do solemnly swear
that I will faithfully, impartially, and justly perform.
that I will faithfully, justly, faithfully,
Impartially, and justly perform all the duties of the office of Highland Park Zoning Board of Adjustment
all the duties of the office of Highland Park Zoning Board of Adjustment
according to the best of my ability.
according to the best of my ability.
I do further solemnly swear
I do further solemnly swear
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and the Constitution of the State of New Jersey,
and the Constitution of the State of New Jersey,
and that I will bear true faith and allegiance to the same
and that I will bear true faith and allegiance to the same
and to the governments established in the United States
and to the governments established in the United States
and in this state
and in this state
under the authority of the people.
under the authority of the people.
So help me God.
So help me God.
Congratulations.
Thank you.
forgot one more announcement. So the meetings will be live streamed via Zoom. Public comments will be allowed for general board matters, excluding applications for the developer.
Mr. Dickerson, I'll have to ask you to sign your oath and I'll notarize it sometime tonight, okay?
Will do.
Okay, go ahead, Mr. Chair.
So members of the public who wish to ask questions, present testimony, or present witnesses in the application for development must be present and in person at the location indicated above. To view or listen to the meeting, you can do this via Zoom. So the discussion about the case is not via Zoom, but just for us in person. I think I want to make that clear too. Now, gentlemen.
Do you want your appearance, please, Counselor?
Sure. Good evening. My name is Peter Oliver, of Hoagland Longo, Moran, Dunstan, Dukas. I represent Alex and Goldie Rabayev with regards to the application tonight. Good evening, Mr. Chair, members of the board. As I mentioned, I represent Alex and Goldie Rabayev, who are here with me tonight. They are owners of the home under construction at 324 North 5th Avenue, and the applicant's looking for an interpretation of Article 230-3 of the Highland Park Land Use Ordinance for accessory building or use. Just to give a little bit of the background, my clients obtained a zoning permit as issued by Michael Mullen, Highland Park zoning official, as well as written confirmation that the planned pool room at their residence is not considered an accessory structure under the municipality zoning ordinance from Scott Brescher, Highland Park's construction official. My clients relied upon those representations and encumbered themselves with $1 million construction loan and began building the pool room portion of their house before their neighbors, the Hollers, filed an order to show cause seeking to prevent that construction. We're here tonight seeking an interpretation because as part of that order to show cause, the court in Middlesex County issued a temporary restraining order and interpreted the pool room as an accessory structure in contravention of the earlier representations of the municipality's zoning official and their construction official. What we're asking the board to do tonight is to support the decisions of these officials, which my clients relied upon to make the call whether the pool room was an accessory structure. And bearing in mind that the court's determination is not final and the board's decision may be of great weight in assisting the court in rendering a final decision. In assisting the board, I brought with me Mr. Robert Longo. He is a principal of Cornerstone Architectural Group, and we'd like to have him brought in as an expert and to provide testimony to the board with respect to why it is we believe that the structure, the pool room that's being built, is not an accessory structure. So with that said, I'd like to offer Mr. Longo's testimony and to qualify him as an expert witness.
Mr. Chairman, I would just note that the board has jurisdiction to entertain the application that is presently before it pursuant to NJSA 40:55D-70B under the municipal land use law. Just so there's no question in anybody's mind. Sir, would you please raise your right hand? You solemnly swear that the testimony you're about to give in this matter will be the truth, so help you God.
I do.
Please state your name and spell your last name for the record.
Robert Longo, Longo.
Very good. Counselor, your witness, please.
Mr. Longo, can you please provide the board with the benefit of your education?
Sure. Again, my name is Robert Longo. I'm principal of Cornerstone Architectural Group. For the record, the address is 202 Hamilton Boulevard in South Plainfield, New Jersey. I'm a licensed architect and a licensed professional planner in New Jersey.
Could you please use the mic?
I'm sorry?
Yes, absolutely. Use the mic. Everything's being taken down.
Just reboot or just keep going?
Keep going.
Okay. I'm a licensed architect and a professional planner in the state of New Jersey. I received my license to practice architecture 37 years ago and my license for planning 27 years ago. Both licenses are and have been in good standing since I received them. I appear in front of zoning boards and boards of adjustment as a regular part of my practice and have done so well over 100 times during the course of my career. And I've been in front of this board at least once before. The most recent project was probably a dozen years ago. We got approval for the Park Avenue Dental Group on Raritan Avenue. When they relocated their office, we needed a variance because the ground floor office was not permitted, or is not, or at least wasn't, it probably still is not in that zone. So that's my most recent appearance, I believe, in front of this board.
So we will welcome you as a witness in front of the board.
Thank you.
I was just about to ask the board to accept Mr. Longo as an expert in the field of architecture and planning, and specifically with regards to the planning issue as to an accessory structure.
We accept.
Thank you. So the primary issue here is definitions. And that's kind of where we are. So I kind of live in building codes and zoning ordinances. I always look at the definitions and what they're trying to say. And the core issue here is that, as the board's probably aware, is the bulk requirements for accessory structures is different than that for principal structures. So if that were not the case, we wouldn't be here. Okay. So accessory structures have smaller setbacks, but they have smaller heights and smaller areas. Okay. So our argument is, and we've been maintaining all along, that we have one structure that incorporates a pool, an enclosed pool within it. So I have printed a couple of large copies of what I believe is Exhibit C in your packet that council submitted. And the only thing that I've done is added some color, this sort of orange color to the drawing, just for clarity.
Can you identify the
Shall we
exhibit?
mark those?
Yeah.
Because they are colorized.
Sure, happy to. Yeah.
Just write it on it and say,
Yep.
Point of order for a moment, Mr. Chairman. There is an objector here this evening, who's represented by counsel. Would it be more appropriate to present any testimony through question and answer so that the objector has the opportunity to cross-examine as well?
so we will have the opportunity for members of the public, which is the objector in this case, to represent and bring up their arguments, and then actually address questions to the witness or to the statements that are given. Like in our sequence, how we do it in the board, we will first hear the applicant and then open up to the public, and you would then.
I understand. My point is that I'm asking whether it would be more appropriate, instead of allowing the witness to give a speech, that it allow him to provide his testimony through question and answer, so that there could be
I
clarity.
believe it's very appropriate for our board to follow our rules, how we move on, and we're very happy to do that. And we will give you ample opportunity as a member of the public or as a member who represents a member of the public to put up your statement and then to have questions to things that are presented.
Thank you.
You'll have an opportunity for cross-examination.
So I have 5 separate drawings here. Am I marking these as 5 different exhibits or collectively as one? What's the board's preference?
Just mark them
Individually?
so we are clear
Okay.
which image you were referring to when you're speaking.
Okay. So if you have exhibits in front of you, I believe there's A, B, C, D. I'm starting with E. The drawings in that collectively were C, and then I think there was an exhibit D as well.
Yeah, exhibit D is the bonus.
I want to know where I should start here. I believe it would be, was there an exhibit D?
This is the last page of exhibits.
Was there a D?
There's a D, but that's not, I think it was all.
So why don't you call it C1 on the board, and then you can go from there.
Perfect.
Please date it, mark it and date it, please.
Okay. back to the microphone. Okay. So this is Exhibit C1. And I should note that I don't have enlargements of all of Exhibit C that are in there. So I just selected Exhibit 5 to be exact. So this is C1, which is a floor plan. And the color indicates the area in question. This is the first floor plan. It shows the entire footprint of the house. And this colored area this is the pool structure here. And this is the connecting link to the pool structure, which shows a connection to the family room. And it shows a bathroom and a mechanical equipment room that serves the pool house, just for context. So one of the arguments that supports the fact that this is one integrated structure is that this building has one continuous envelope. It shares a continuous foundation. It has a direct connection to the family room structure, part of the home. The mechanical systems, electrical systems are integrated with the building. There's like one electrical service coming to the building that's served from the basement in the main part of the house. It lacks some independent means of egress, meaning we're going to this structure, this pool portion of the structure from within the main portion of the structure. And you will see in the following drawings that architecturally, from both massing and stylistic viewpoint, it's integrated into the main context of the house. So I think it's important that we understand that typically an accessory structure is something that's detached. Well, think of a garage or a shed, right? We have a home and we detach something and we call that accessory because it's something that's on the same lot, but it's not connected to or not part of the principal use. So it could be, again, it could be a cabana, could be a garage, could be a shed, it could be a number of things, right? A play structure, things like that. This clearly is very different than that. This house also has a garage. The garage is integrated with the home. It's underneath the second floor, very typical. So that is the layout that we have, just sort of for context. The next drawing is C2. So the next four drawings are the four elevations, front, sides, and rear. You'll notice that this is the front elevation. You'll notice that there's nothing colored here because the area in question, meaning the pool enclosure, is not visible from the street. So that is what the facade of the house looks like. And I wanted to show you this again, just for context, so we can understand how the pool enclosure looks in context with this architectural style. This is Exhibit C3. This is the right side of the house, or what would be the west side of the house.
Catch that. I want to find the drawing.
Oh, I'm sorry. Yeah. Thank you. So what's colored, again, what's shaded here is the area in question. That is the pool enclosure and the connecting link. So again, you can see that it's got a similar architectural style. It's got a similar massing. It's clearly integrated into the rest of the house architecturally and from a massing standpoint. This is the opposite side, the left side. C4, yes. C4. On the left side is the west elevation. So again, this is the pool enclosure. These two large openings are bifold doors that would open up the pool to the yard. But again, you can see that the mass is similar, the roof line is similar. It is part of one integrated structure. This exhibit is C5. This is the rear elevation. Again, the shaded portion is the pool enclosure. And again, the point being that the massing, the scale the architectural style is consistent with that of the main building. So those are the primary characteristics that we believe support the fact that this is part of the main structure and not an accessory structure. So some of the definitions, so your zoning ordinance that defines accessory structure with 5 criteria. So it's 230-3 in our definitions. It says an accessory building or use is subordinate to and serves an ancillary purpose of the principal building. Now, these are 5 criteria, A through E, all which must be met. It says it's in subordinate, it is subordinate in area, extent, or purpose to the principal building. It contributes to the comfort, convenience, or necessity of the occupants of the principal building or principal use served, and is located on the same zoning lot as the principal building or principal building served. And then E says may have a sink, electric service, heat, and or air conditioning, but does not contain a bathroom, toilet, kitchen, or cooking device. So these are exclusionary types of language here, right? So the ordinance is trying to prevent from somebody building a garage and putting in like a bathroom and a kitchen. It's trying to suggest that these are independent structures, like disconnected from the existing building, right? So, because it says it must be on the same lot, which means that you couldn't have a house and build a detached garage on your neighbor's property. Or you couldn't have 2 adjacent lots that were, say, contiguous, but not one parcel, and you couldn't have a house on one and a cabana on another. It must be on the same lot. So that infers that it's a separate structure. And the fact that this addition, going back to C1, you look at that link, there's a bathroom like in this link. This is all part of the area in question. In definition E, it says does not contain a bathroom, toilet, kitchen, or cooking device. So the presence of that bathroom alone, by this definition, prohibits this from being an accessory structure, just by that sentence alone. I think that's all I really have on direct, unless you have other.
No, unless the board has any specific questions for Mr. Longo.
Do you have any questions at this point?
Mr. Longo, can you describe the doors between the pool room and the family room? Is those simple interior doors, or are these doors with deadbolts and into a separate section?
It's a standard 3-foot swinging door. I can't speak to the locking of it, but it's a 3-foot swinging door that might connect to any other 2 spaces in the home.
Similar to the other interior doors in the house.
Correct.
Thank you.
Yeah.
I don't know if I asked this right. Is there any interpretation under which the little blue or the little orange part could be interpreted as the part of the structure on the right rather than on the left?
I mean, I suppose that's part of what the board's here to determine. Then are you suggesting?
I'm not suggesting, I'm just saying, is there an interpretation that it could be that way?
I suppose.
Yes, please, Chris.
Actually, building on the board member's question, is there an exterior door to enter the room that's labeled pool?
There are bifold doors, like large bifold doors that would lead to the outside. Other than that, no.
No more questions. Is there a question?
Is the bathroom accessible from inside of the pool room or from the kind of hallway?
So both of there's 2 doors. So there's this connecting link here. So there's a door here, and a hallway.
Right.
So both the mechanical room and the bathroom are off of the hallway that connects the 2. So in the judge's opinion, all of this, everything I've shaded here, the judge considered to be accessory. In this entirety, yeah.
Mr. Longo, in your experience when dealing with accessory structures, I know you mentioned something that's detached, like a garage or a shed. Have you ever seen something like this where it has a similar foundation and it's contiguous with the building where it's been deemed an accessory structure?
No, my experience, whenever there's attachment, it's going to be part of the principal structure.
Are there other questions from members of the board?
Is access to the covered terrace strictly from the hallway?
It's from the exterior or from the family room, actually. It's from the family room, there's doors here,
Okay,
or from the patio, from the outside.
but it doesn't connect to the pool room or the hallway.
Oh, it does, it connects to the pool room with sliding doors, so not to the hallway. Pool room, family room, and outside. So all three sides, but not this link.
Thank you.
Good. Do you have any other?
Yes, I would also like to have my client, Goldie Rabayev, testify about her reliance upon the zoning and construction officials' decisions in building the home and to basically build the house of her dreams. And I'll ask her to come up and testify. And thank you very much, Mr. Longo.
Good evening, ma'am. Could you raise your right hand, please? Do you solemnly swear that the testimony you're about to give in this matter will be the truth, so help you God?
I affirm.
Would you please state your name and spell your last name for the record?
Sure, it's Goldie Rabayev, Rabaev.
Thank you very much. Counselor, your witness?
Is it okay if I take this out?
Sure.
It's a little bit
Go right
tall.
ahead.
Absolutely.
Okay,
Just
can you still hear me?
Yes.
Okay. So I wrote, what, you're.
Ms.
gonna say
Rabayev, I
things?
know you have.
Can you
some-
please also use the microphone?
Sure.
Because we make sure the
Yeah.
recording is correct.
Ms. Rabayev, I know you have some comments that you prepared with regards to
Thank you.
what it's meant to you with regards to building the home of your dreams, getting the approvals from the zoning and code officials to start that addition, the pool room, and the construction, and then to have that stop. So I'd like the board to hear from you with regard to that.
Okay. Hi, thank you for hearing us today. I had to write my thoughts down so that it would be more concise. I do want to say that it's really good to see a lot of friendly faces tonight. This has been an incredibly lonely and traumatic process for us. Many people here know that we are unfortunately way too familiar with trauma, and so I don't use that word lightly. In all honesty, being here tonight is just a little bit surreal. When I first heard about this meeting, I didn't really realize that we would have to be present. I've never done this before, let alone that I would have to speak, let alone that I would need community support. I kind of thought this would just be a formality. At the end of the day, we obtained all the required zoning and building permits from the township. That was not an easy process, but that's to be expected when undertaking a major construction, project. We were rejected twice before our plans were ultimately approved. And ironically, it seems that once that we satisfied the townships, our neighbors became dissatisfied. Or perhaps not ironically at all, considering the fact that the neighbors challenging our project and their attorney, who's also a member of our community, have sued multiple neighbors before, and perhaps this outcome was inevitable. Throughout this process, we worked very closely with the township officials, Mr. Mullen, Mr. Scott Brescher, as well as our engineering and design team, to identify, address, and eliminate any inconsistencies related to building and zoning requirements. This was not a situation where corners were cut or questions were ignored. We invested significant time, effort, our resources to ensure that our plans complied with all the applicable township regulations before the construction began. This meeting, I guess in my mind, was supposed to be very straightforward. Our plans were reviewed and supported by the zoning and building departments. The question of whether the structure was an accessory has never, it was never brought up, not once. It seems like a simple matter of the zoning board to stand behind its own professionals, to reaffirm that the zoning officers understood the township's own regulations and properly issued our permits. Instead, I found myself living in this version of the twilight zone where a court ruling can impose financial and emotional burdens over circumstances that we had no control over. Despite the fact that we followed all the rules and we did everything that we were told to do, we're still in this situation. So now I would like to explain why this house matters to us, to my family. Many people in this room know that in March of 2021, my husband and two of my younger children were involved in a devastating accident. We were skiing and a ski lift disconnected and fell 30 feet. My husband, in those seconds, pulled my kids onto himself, preventing them from injury, thank God, but sustaining very serious, at that point in time, life-threatening injuries of his own. When he entered his first surgery, the doctors estimated that he faced 37% chance of death and more than 95% chance of paralysis. Today, he's walking, and he is truly a miracle, and we thank God for it every single day. What most people can't see, however, is the chronic pain that he lives with, the deterioration of his hip joints, because they're joined together by a huge nail, and the early onset of arthritis. Now, my husband's only 48 years old. He has an entire lifetime ahead of him. And the best way for him to preserve his mobility and the quality of his life is through constant physical exercise that he has to maintain every single day, multiple times a day. So this is why I'm sharing my story. For years, we searched for the right property. We worked with architects and explored numerous possibilities. This house is our dream home, not because it's extravagant, but because it is designed around our family's needs. We specifically chose this neighborhood because our home would fit in naturally among the other large homes that are right next to us and in front of us. Including the home of my neighbors that are suing us right now. Those neighbors had described our home as a monstrosity, the word that the judge adopted into his characterization, yet our home is no larger than theirs. What truly seems to bother these people, is that we're building a pool. But the pool is not a luxury for us. It's a part of a long-term plan to ensure that my husband has reliable access to non-weight-bearing exercise that his doctors have insisted on. It is also a part of a design that would allow us, and God forbid, I hope this never happens, but to adapt our home so that our primary living space, as well as our master bedroom and everything that we need, is on the first floor. It feels surreal, and frankly, it feels violating that I have to publicly explain deeply personal details about my husband's health and our situation, but here we are. What makes this situation even more difficult is that we were not stopped at the beginning of the process. We were prevented from continuing construction only after the structure was already erected and approximately 7 months into active construction. By that point, the structure was erected. Substantial work had been done, completed, in reliance on the permits that have been reviewed and issued by the township. Had these issues been raised before permits were granted or before construction had progressed, maybe we would be able to do something different. Meanwhile, the consequences of this litigation have been really severe. The existing structure has remained exposed to the elements for virtually the entire period, which is like 9 months now. Up until this week, the house has sat through rain, snow, freezing temperatures, seasonal weather, without the protection that would normally accompany a project at this stage of construction. Significant damage has already occurred as a result of this exposure. Our construction loan is now in default because we were unable to meet construction requirements. Our insurance coverage is set to lapse in July. The financial and emotional strain on our family has been immense. As I said earlier, I expected tonight to be a little bit more than a formality, but this past Shabbos, this past Saturday, numerous people approached me in our synagogue and told me that Liam Haller had actively encouraged people to attend this meeting and support this campaign against us. Because of that, we were advised to ask our own friends and neighbors to come here tonight in support of us. I'm asking the zoning board to uphold the determination that the zoning officer has made. My understanding is that this issue remains critically important because the court's decision is not final, as our attorney stated, and ultimately the zoning board is the authority responsible for interpreting and applying the township's own regulations. The property owners cannot rely, if the property owners cannot rely on the permits that have been given, properly reviewed and issued by the township, implications will extend far beyond my family. They would affect every single resident who seeks to build or renovate or to improve their property in reliance on the township approval process. We followed the rules. We worked with the township officials. We addressed every concern that was raised to us. We obtained the required approvals. We invested substantial resources in reliance on those approvals. We acted really in good faith. Every step of the way, I respectfully ask the board to stand behind its own zoning officer, behind its own regulation, behind its own professionals, and say that the permits were issued properly and in accordance with your zoning laws. Thank you so much.
Thank you.
Thank you.
Does the board have a question? From the board? So thank you so much.
Thank you, board members. This was brought to my attention. I also want to note that there has been a number of reports by members of your own zoning commission who've issued reports that are in line with the zoning officials, that this is not an accessory structure, and we would simply ask that the board issue an interpretation consistent with that. Thank you very much.
So there's no other question from the board, then this will be open to the public, and you're welcome to ask questions to the witnesses of the applicant.
Good evening, Counselor. Could you enter your appearance, please?
Yes, absolutely. Good evening. My name is Elliot Ostro from the law firm of Epstein Ostro, and I represent Leon and Susan Haller, the next door neighbors to the property in question. Earlier this afternoon, my office submitted to the board our written objection to the relief that is being sought by the applicant this evening. I did bring hard copies for each of you if you'd like me to hand those out now, or I can give it to you afterwards, whichever the.
So it would be probably you hand them. Can we receive them now?
We can receive them now. I mean, were they electronically?
They were electronically submitted this afternoon, and I'll apologize to the board for you know, a relatively late submission.
I'm sorry, we would object. We didn't have an opportunity to fairly respond to Mr. Ozerov.
When the capacity as the board attorney, yes, I'm of the opinion that it was certainly, whatever was certainly filed at the 11th hour. And the fact that this has been on the agenda for some time is somewhat of a problem. I mean, though the law would allow your brief or submission to be part of the record. I mean, it should be noted that, you know, it is filed very late, and it's highly unusual to do that in such a proceeding as this.
Well, I'll respond in a few ways. First of all, I apologize. I did not receive notice of this hearing and this proceeding until on Friday. And I was out of the office last week. My son was getting married last week. And so I was out of the office and I did not receive notice. And to the extent that the applicant's counsel here is objecting, I'm a little disappointed, frankly, because they didn't bother to send me a copy of the application when they sent it.
Had you entered
Notwithstanding,
an appearance in this matter?
I didn't know the matter existed.
Well, then in that case, then why is why are you objecting to that?
Well, and to be clear, then what you saw in the applicant's papers is that this is the question that's been presented to this board has already been presented to the Superior Court of New Jersey, Middlesex County, and Chancery Division,
Which has not entered a final order.
Which has considered the issue both on a temporary restraining order application.
Has not entered a final order.
Could I ask the gentleman, because time is limited a little bit, that my suggestion is that I personally say that as a chair of the board, that I would welcome you hand them out. And
yes.
While you're presenting, we can look at it.
Sure.
And then we can shut this. And I think this is nothing objectable, like nothing illegal that I'm doing right now. It's unusual, but it's not.
It's highly unusual, but you can do it, yes.
So I think in full, making sure that everybody is fully heard in front of the board for the peace of the community, I would suggest that you hand it out. And we can then follow your presentation as it will be coming to into the records afterwards.
Members of the board, I would also note that the Howlers received notice and that this matter has been on the agenda for some time.
That was my understanding from Mr. Thomas as well. And this is hardly a new case.
Right, but I think it's not more difficult, it's easier for us if we follow, and then we can do that.
Mr. Chairman, your word is final. I'm just making sure that you understand what the law is, and I'm advising you because it's appropriate that you're aware of it.
Yep.
What I've shown you here is attached as Exhibit 2 to my submission as well. This is the current view, or it was the view from the Howler's back deck. And what is
You can use my easel if you like.
I appreciate that. But the truth is that what's been presented to the board this evening is a question of interpretation, right? And so the question of interpretation doesn't necessarily mean that we need to consider the specific situation of the Rabayevs, the applicant. It doesn't necessarily mean we need to consider the specific situation of the Howlers, notwithstanding the current view of from their deck. But most important before the board here is a question of the interpretation of your zoning ordinance, right? And
as it pertains to the structure.
Yep. I didn't interrupt you.
He didn't interrupt you either.
Your zoning ordinance, the Highland Park zoning ordinance. Section 230-3, the definitions. We start.
Can we ask a question?
We should finish. Let's finish the presentation.
I just wonder what the picture is.
Oh yeah.
This is a photo from the Howler's deck. The wooden structure that you see is the pool house that the Rabayevs have started to build.
Okay, so there's like a pool house, and then there's also a what do they call it? It's like a deck or something. Are we looking at the pool house itself, or are we looking at the side that's?
We're looking at the side of the pool house. So you're looking at, if I look at C1, that was a part of that application, you're looking at this area right here.
Thanks.
Chris?
right? Because the Howler's house is over here.
Okay, now I understand.
As one of the two board professionals, can we look at it too?
Just want to authenticate that you took that picture or someone in your.
Mr. Howler is here. He took the picture. We can ask him to authenticate it for you if you want.
All right, that's fine, but no, you have a question for Mr. Cosenza.
Yes, I just want to see the photo. Can you describe again where it's taken from and when you took the picture?
This picture was taken actually in September of last year. And I'll orient you. The house on C1, the Howler's house is next door here.
Well, can you please make sure that you use the mic whenever you explain something?
Yeah.
It's on the record.
Everything is being taken down, so you're.
Based on the orientation of the design of the diagram here, the Howler's house is above their back deck is over here. And what you're looking at in that picture is the side of the building.
Thank you.
Look,
Excuse me, sir.
yes.
On page 24, is that the Howard's house? Your handout. Yes.
Yes. Yes, sir.
Approximately how far apart, I guess that's the deck, is the white fence there?
The white fence is around the deck, correct?
Yes, from the white fence to the structure now.
It's less than 10 feet.
Okay.
The question that's been presented to you has been presented to the court. It was presented originally to the court back in September of last year. On October 1st, the court entered a temporary restraining order based on its opinion that the Howlers had demonstrated a likelihood of success on the merits of their claim that the structure that was being built is inconsistent with Highland Park zoning ordinances. The revives, through their counsel at that time, made an application to vacate that temporary restraining order. The court considered their arguments and denied that application. To the point where it was noted this evening that the structure has been and it remains open to the elements. Back in December of last year, the court modified its temporary restraining orders so as to allow the revives to winterize the structure. They didn't, and for whatever reason, they didn't, but it wasn't done, and it wasn't because they weren't allowed to. The court allowed them to do that. In January of this year, in January 22nd, the court held a full day hearing, accepted witness testimony. The testimony of Leon Haller was presented. The testimony of certain professionals working on behalf of their buyers was presented. And the expert testimony of Mr. Longo on the one hand and our expert, Mr. Del Vecchio, on the other, was presented to the court with respect to questions regarding interpretation of the zoning ordinance. A court issued an opinion. That opinion is attached to the applicant's papers, actually, and that opinion concluded that the structure is being constructed inconsistent with the Highland Park zoning ordinances. Now, why is that? Why is that? So I do have a couple of questions for Mr. Longo, and I will ask those in a few minutes, but I want to go through what the analysis really should be, because Mr. Longo respectfully skipped several steps. First, we start with the definitions. Definition, section 230-3, the definition of a swimming pool. It's important to note the definition of a swimming pool, because the definition of a swimming pool, according to the Highland Park zoning ordinance, is any body of water used or intended to be used for swimming. I'm skipping some words because it's, swimming by the owner and his family and his guests, constructed, installed, established, or maintained inside or outside any building. That's the definition of a swimming pool. A swimming pool can be either inside or outside.
Sure.
By definition. Section 230-132 of the zoning ordinance. Section B is titled permitted accessory uses. A permitted accessory use, section 230-132B, number 3. Private recreational facilities such as, but not limited to, swimming pools. By definition of the Highland Park zoning ordinance, a swimming pool inside a structure is a permitted accessory use. Mr. Longo seems to have skipped that part, but
You have to address it now if you'd like.
I'll have questions for you when it's time, right? Right. Section 230-126 of the Highland Park zoning ordinance. Conformity with regulations. Section A of that code section says, no building, structure, or land shall hereafter be used or occupied, and no building or structure or part thereof shall hereafter be erected, constructed, reconstructed, moved, or structurally altered unless in conformity with all of the regulations herein specified. So both a structure and a part thereof have to be inconsistent with the regulations. And then we finally get to the definition of an accessory building or use. Accessory building or use is defined as subordinate to and serves as an ancillary purpose to the principal building. What we have here, the principal building, I'm pointing to C1. We've got the unshaded area, the principal building, and the smaller pool house, subordinate to and ancillary to the use. The purpose of the principal building is not to go swimming. The purpose of this principal building is to live in it. Happen to want to swim also, which I understand, but that structure is ancillary to the principal use of the building. It's subordinate in area, extent, or purpose of the principal building. Again, it's smaller than the rest of the house. The purpose is to house a pool, which is subordinate to and ancillary to the purpose of living in a house. It contributes to the comfort, convenience, or necessity of occupants of the principal building. Mr. Abayev explained to you how this pool contributes to the comfort, convenience, and necessity of the occupants. It fits that definition as well. Is located on the same zoning lot as the principal building. That's true. It's on its lot, and it may have a sink and so forth, but cannot contain a bathroom. And it was curious, and it's a little interesting because when we look at C1, Mr. Longo chose to highlight for you as part of the pool house this hallway that has a bathroom. of the main house, according to the architect who designed the building.
Just a question.
Yes, sir.
You could have an accessory use in a principal building.
Of course you can. Of course you can. Right, but the question presented, the interpretation of when we want to interpret this is, what is, if this is a principal, an accessory use connected to the principal building, what are the height and size limitations on that, right? Because the Highland Park zoning ordinance, section 230-149.5 provides that the gross area of floor, no accessory structure. Now, here's what's interesting. It's right, because we're talking about statutory interpretation. And so we got to look at the words of the Highland Park zoning ordinance to figure out what they mean. It says no accessory structure in conjunction with a single or two-family dwelling. Right? What's interesting is that when we've read each and every one of these sections, the word attached doesn't exist.
Are you testifying as an expert, sir?
No, I'm reading the words to you, right? The words detached aren't in there.
Blurring, you're kind of blurring the distinction.
Okay, Mr. Longo.
Yes.
I got some questions for you. Why don't you come up and grab a microphone and we could do it that way instead.
Right.
Okay.
Oh, if you want to testify, I'll swear you in.
No, I don't need to testify.
Attorney's witness here would not be appropriate.
Yeah, totally fair, totally fair. So Mr. Longo can testify for us because he's been presented as the applicant's expert. Mr. Longo, you've had an opportunity to review the Highland Park zoning ordinance.
I have.
Right, and you've reviewed each of the sections that I've presented to the board so far?
I have.
Okay, and within your review of those sections, did you note anywhere the requirement of an accessory building to be quote unquote detached? Is that word detached in the zoning ordinance?
I believe it's inferred. It's not read that way.
It's inferred, but it's not in there. You're inferring it, correct?
I'm inferring it as is the zoning officer in the board's plan. Yes.
Yeah, right, all right. So, the word attached, right? Creating an exception for an accessory structure that is otherwise attached to a primary residence or a principal structure. Is the word attached found anywhere in the Highland Park zoning ordinance?
As it relates to what?
As it relates to the accessory structure or a swimming pool accessory use?
No.
Right. Mr. Longo, you testified earlier that you've done this in many other townships, and it's been your experience that in many other townships that there's when an accessory structure is attached to a primary residence, is considered a part of the primary residence. Is that right?
Correct.
Right. And in connection with that experience, did you have the opportunity to review the zoning ordinances in those other towns?
I did.
You did, right?
I've been doing this for a long time.
Okay. So. Have you ever done an application in the borough of Metuchen?
I'm not sure what the borough of Metuchen is relevant for us.
Well, if you allow me to, two questions, I'll explain.
I'll get here really quick. I can find zoning ordinances that have the word attached, and I can find zoning ordinances that don't have the word attached, if that's where you're going.
Well, it is where I'm going, because what you're doing.
Metuchen may or may not do is not germane to this proceeding.
Well, that's true, and similarly, Mr. Longo's testimony that he's done this in lots of other places, and in lots of other places they thought about it in one way, is not germane to this proceeding either, right? Because what's before this board is not.
Please give us it's not based upon how many years, and how many municipalities you've indicated.
Can we move on from this point?
Yes.
Well,
Yes, we can. Mr. Longo, you testified about some of the characteristics that you took into consideration when coming to the conclusion that the Highland Park zoning ordinance necessarily means that if the structure is attached
to the primary residence, it must be a part of the primary residence.
I think it's inferred and it's certainly part of the discussion.
Yeah, well, it's part of the discussion because you put it there, right?
Yeah.
Right, because the words aren't actually there.
I'm not suggesting that this is an accessory structure only because it's attached. I'm saying the attachment is a factor in that consideration.
But does that factor into the board's consideration of the definition of an accessory structure or under, right? It's interpretation of its zoning ordinance.
I think we could ask the board's professionals that question.
Okay. So, well, I'm asking you because you testified. So one of the factors that you testified to is that you explained to the board here this evening that that you noted that there's one continuous envelope, correct?
Correct.
Right, and within the definition, section 230-3 of accessory building or use, do you find the words continuous envelope?
No.
Do you find that the ordinance itself considers whether there's one continuous envelope a part of the definition of accessory building or use?
That's my opinion as an architect and a planner.
Right, but it's not actually in the words of the zoning ordinance, correct?
No.
Right, you also testified to this board that there is a continuous foundation.
Correct.
Right, and within the definition that you're asking, the applicant is asking this board to interpret, this definition does the definition itself take into consideration whether or not there's a continuous foundation?
No, it wouldn't in this ordinance or any other. That's
right.
Foundations are not part
mechanical systems and electrical systems that you say are connected. Is there an exception to the definition of accessory building or use within the Highland Park zoning ordinance?
All of those items you're mentioning go to the term subordinate.
No, all of those terms I'm mentioning are the ones that you use to explain to the board why the definition of accessory building doesn't apply to here. And what I'm asking you, sir, okay, is follow my question here. What I'm asking you is, where in the definition, according to Highland Park zoning ordinance, does it say that you should take into consideration whether the mechanical systems and electrical systems are fully integrated?
The definition says accessory building is subordinate to in area and extent. Subordination means it's separated somehow. So if it shares a foundation, if it shares mechanical systems, if it shares electrical systems, if it has a continuous envelope, then I argue that alone means it cannot be subordinate. So therefore it cannot be accessory by their definition.
You testified to the board that the existence of the bathroom here necessarily negates the possibility of the section being an accessory structure, correct?
230-3E.
Right.
Correct.
Right, 230-3E. So hypothetically, if I moved this to over here so that it was not connected to the house, and I kept the bathroom in it over there, would that necessarily negate it being an accessory structure?
Hypothetical is not before the board. I'm going to object to that.
Okay.
I just told you. I said a hypothetical is not before the board. Therefore, I'm objecting to your query.
Well, I'd like to add that the reason that I colored in what I colored is because that is the area of the building that the judge said was accessory. So that's the reason I included the bathroom in the colored area, because that is what the court said was accessory, and that's what we disagree with.
So, Mr. Longo, are you explaining to the board that what you're doing here tonight is asking them to overrule the judge?
I'm just explaining why I included that.
This is not as far as I understand, and you may correct me on that, it's in front of the zoning board to identify if this element of the building is an accessory building or not. And we just, as a board, we have to be clear that this is fully within the current zoning and rules and regulations of bulk variants, of bulk volumes, and of distances to the property line. This is what's allowed within the, just for us to, when we listen, to make this clear. So the question is, If this is identified as an accessory building, different rules apply. If it is accessory building, different rules apply than if it is part of the main building. And that is the question for us as a board to understand. This is what we're listening to and
Correct.
appreciate to.
Yes,
A
sir.
comment about the bathrooms.
Yes, sir.
I don't, it's not clear that you can separate the bathroom from the pool. There's a rationale about bathrooms there because of the pool.
The architect who designed the building separated it from the pool, right? The
I think
architect.
that's like-
It's not the reason you're stating.
I'd like to address that.
Well, of course it is, it's the same plumbing, it's in the same structure, but
That doesn't negate what the job here is today, right?
Right, so this connecting piece includes the bathroom, which is discussing, it also includes the mechanical space, which is exclusively for the pool, therefore, you can't separate those two as it's designed. I mean, certainly you can create a hypothetical where you can do that, but that's not what we're talking about today. And to address Mr. Osborne's just notice about, these areas, I mean, these areas are broken down. This building has different foundation types. Okay, the pool enclosure has a conventional foundation, and the main house has a basement with a prefabricated foundation system that has insulation integrated in it. It's a superior wall system, which some may be familiar with. So since the pool has no basement, that system is not appropriate for a pool. Also, the collateral load from a pool is different than the structure of the basement. So it necessitated having two different types of foundation systems. So this diagram simply says, hey, this is a garage. That's different than the main house. Yeah, because the garage is a slab on grade, like my house, probably like yours. Oh, and this part has a basement. That's the main part of the house. Oh, and this pool house, the pool room, is different because it's got a different type of foundation. Doesn't mean anything in terms of this discussion. Simply means that the architect here chose three different foundation systems that make sense for this structure.
Yeah, sure.
We're not being asked to overrule the judge. The judge has simply asked us to opine on the zoning ordinance as he sees us as the appropriate body. to
That is
rule on.
correct.
Thank you.
Mr. Hotel, I actually need to correct you. The judge hasn't asked for this at all.
The judge has asked us.
No.
He has deferred to us here.
No, he has not. The
No,
judge
that's
has not asked for
I'd like
this
to-
application.
The authority for what the, excuse me, please. The authority for what the board is doing is set forth exactly in the MLUL. So this board does have the authority to do what it's doing. For you to refer to it as anything else is incorrect.
Mr. Gibbons, I apologize. I wasn't suggesting that the board doesn't have the authority to hear this application. What I'm explaining is that the court.
Other than an esoteric exercise, which
the court.
Certainly, that's a kind of an inflammatory statement.
The court has not asked for this hearing. The court has not asked for this interpretation. The court has already made the interpretation.
But that is
The
not
applicant-
positive on this board.
I'm not suggesting that it
Well, then
is.
why are you saying it is?
Because I want to correct the misunderstanding.
I think the misunderstanding may be yours, sir. Yes, sir. What?
Sorry, I'm reading, the applicants now request that the board interpret the relevant provisions of the ordinance. It's not the court, unless I'm reading this.
That's right. The board is making the interpretation, which is, as a matter of law, it's right.
Yeah, but it was the applicants who requested this.
Yeah, so the applicant.
It was not the courts.
The applicant has asked the board to give an interpretation,
Yes.
which the board has the express authority to do.
Yes, I agree. Yeah.
The court
I'm just
hasn't
saying
made
that
a
the
final
court did
judgment.
not ask for this.
I'm sorry,
The
sir.
court has not made a final judgment.
No, I said that earlier, and I think it needs to be emphasized that whatever the court has said to this point is not binding on this board. This board is acting of its own authority. Counselor?
Let me sum up for you because
That would be advisable.
I appreciate that. Thank you. Mr. Longo, I have no further questions. Rich. Being dissatisfied with the court's ruling. The applicant has now come to you to ask for a second opinion. Now, it is correct that it's consistent with the municipal land use law for the applicant to be able to do so, and it is within your authority to do it. There's nothing wrong necessarily with it. But we do need to put this into context.
Then how can you say, being dissatisfied, the applicant has now come to the board? I mean, it is exercising its express right, an expression of dissatisfaction? That's not correct.
Because the applicant was dissatisfied with what the court ruled, they're asking you to second guess the court, make a different decision, maybe agree with them, so that they can present something to the court prior to a final resolution.
That's
right, and which is consistent with the municipal land use law. But the question before you, and I'll say it quickly, but once again, because the question before you is relatively simple. It's one of statutory interpretation. It's your job that you do every time you get together, right? Your job is to look at the zoning ordinance and interpret the zoning ordinance, right? And when you do that, you have to read the zoning ordinance all together. They have a pool that is by definition under Highland Park zoning ordinance an accessory use. They have a building that yes, sir.
Is it a pool is an accessory use, or it can be accessory use?
It is by definition accessory use.
Potential.
No, not a potential. Not a potential. Section 230-132B3. Single family residential zone. The following regulations shall apply in the RA residential zone. B, permitted accessory use. B3.
Yes, potential.
It's not a potential. It is by definition. It's your definition.
But the question isn't if there's an accessory use, it's if this is an accessory. It's an accessory building.
Oh, so go back to the definition of accessory building or use. Your
Mr. Chair, can I address that?
No.
If you finish your sentence and then it would.
No, it's not for you to say whether he can or not, sir.
Oh, I'm in the middle of something here.
I understand
So
that, but for you to just say no is inappropriate. You're out of order.
So if you would kindly finish your
Sure.
thought and then the applicant.
Section 230-3 definitions, accessory building or use, right? Your definitions don't distinguish between a building or a use. And a pool, by definition, under your definitions, is an accessory use. And
What's another accessory use?
I'm sorry?
What's another accessory use potential or permitted?
Private recreational facilities such as, but not limited. I will sum up this way. without repeating myself again, the plain words of your zoning ordinance necessarily make that pool house an accessory structure that's limited in size and area by by the zoning ordinance, right? That the plain words, right? Now, you asked me before, and I'll tell you, I'll touch on it briefly. When I was referring to other townships, right? The reason why it's relevant to consider and for you to consider when you're trying to interpret your own zoning ordinance, what other townships ordinances say, is because, again, we are looking at the words that were chosen by the drafters of the ordinance, right? And then when the drafters of the ordinance had the opportunity to draft the definition of accessory structure, they had the opportunity to do what other townships have done. They had the opportunity to say an accessory structure is A, B, C. However, provided, however, when an accessory structure is attached to a primary residence, it may use the height requirements of the primary residence. Right? They had the opportunity when they chose to define an accessory structure in your zoning ordinance. They had the opportunity to say that an accessory structure is one that is detached from the primary residence. They had the opportunity to say that a primary structure, excuse me, an accessory structure by definition is not attached to the primary residence. They had the opportunity to do that. The drafters of your zoning ordinance chose not to. It's important to know that because it's irrelevant under a Highland Park zoning ordinance whether the building here, this box that contains the pool, whether it's attached to this or it's over here, completely separate and apart. The words of your zoning ordinance don't make a distinction. And so you're being asked to interpret your zoning ordinance, not the fantasy that Mr. Longo was presented, right? Not somebody else's, not the experience that he's had in other townships. Your zoning ordinance does not make a distinction that under the definition is an accessory structure. Now, yes, sir.
It's hard to see how that section is subordinate in structure.
Sure.
It's going to be subordinate use, but I don't see how it's subordinate in structure.
Well, it's subordinate in two ways, right? I mean, first of all, in square footage, it's smaller than this, right? And also, it's subordinate as well in height, right? Because the main house is about 36 feet plus high. This is 29 feet high.
So I think that's for us to discuss later. We do not need to convince you. You presented your case, and I believe you did this really well. And we can probably. And you finished with that?
Yes.
Good. Thank you.
Can I ask a clarifying question?
Okay, sure.
Sorry about the point. So if I understand your argument is that a pool is always accessory, even if we're in the middle of the house. Is that what you're arguing? I'm just trying to understand.
I guess if you're trying to picture a pool, say in the basement under everything and in the middle of the house, then we wouldn't be having this conversation, right? Because the height wouldn't affect wouldn't be seen from outside. It's the basement up to wherever the first floor is, right? In the middle of the house, the pool, all right, if the pool was here, right? If the pool was here, then it wouldn't be this separate structure tacked onto the back of the house. Right? And so the building, there wouldn't be a separate building surrounding just the pool, like you have here.
Related to that, it's actually a good question. If Gym equipment was removed. It's just a room. Would there be an issue with that?
No,
So the issue is the use, not the structure.
the issue is the structure housing the use.
Understood. Thank you.
Oh, you're done.
Thank you.
Thank you.
But I think we're struggling here with trying to make ordinances perfect, and of course, none of them are, right? So there's always some wordsmithing to do here, but Mr. Osborne is trying to argue that because your ordinance says pools are accessory, that every pool must be accessory. That simply isn't true. Otherwise, this house is a two-car garage, like many homes do. Probably most of your homes have a garage integrated. No one's arguing this garage is an accessory structure. So why are we arguing that the pool is accessory structure? Mr. Osgrove said, hey, look at this diagram. There's a separate line around here than this. So this thing must be a different thing. Well, there's a separate line around this garage too. Like I told you before, the reason that is because the garage is a slab on grade. There's a reason that looks different. No one's suggesting that that garage is accessory. So why is the pool any different? The reason, in my opinion, is it's not. I want to read definition of swimming pool for you because Mr. Osgrove, conveniently didn't read your whole definition. Okay. Swimming pool, private. Any body of water, tank, or receptacle for water, whether artificially or semi-artificially constructed or pourable, having a depth at any point greater than 18 inches, or a diameter of, or an area over 120, or a diameter of 12 feet. Used or intended to be used for swimming or bathing, solely by the owner, his family, and guests, blah, blah, blah. That would make my bathroom, and probably your bathroom, an accessory use. It would make 4 bathrooms in this house an accessory use. So if we use Mr. Osgrove's definition, we have an accessory garage, we have 4 accessory bathrooms, because they contain swimming pools by definition. Now, I'm not suggesting that your ordinance would consider a bathtub to be a swimming pool, but clearly these ordinances are meant to be interpreted. And I don't think the board's going to suggest that a bathtub is a swimming pool, but that's what your ordinance says if you read it strictly. So that's why we're here, to get your opinion as to exactly what this ordinance means.
I was.
You need to speak in.
I'm going to. I just gather my final thought for you here, which is that, I started off by noting for you that unfortunately I'd received late notice of this hearing. Whether that makes a difference to you or not, it is irrelevant. It's a fact. As part of
your objection is a record, just so you know. I mean, we didn't strike it.
Well, of course you didn't. So you right there.
Well, yes, of course we didn't.
Right.
But the fact is that it came when it came.
All of that is true. Yes. The point that I was making in noting that for you is that at the time that this question, the same question that you're being asked to interpret today, was presented to the court, we had the benefit of our expert architect as well. And I would ask you if you think it makes a difference to you. And if it doesn't make a difference to you, then it doesn't make a difference. But if you think it would benefit you to help you in coming to your decision, to hear from our expert architect, I'd ask that ultimately that at the end of this proceeding that you continue the proceeding to another date so that I have the opportunity to present it. Thank you.
Thank you. Is there any other member of the public who wants to have a question? Good. Yes. I think you should probably want to come up here.
Yes, you should come up and speak to the microphone. Please identify yourself and get your address, please.
Yes, please.
Yes, please.
It's relevant.
Okay. Hi. My name is Ricabella Lefkowitz. I am the Rabia's oldest daughter. And do you want me to spell my last name? Sorry.
Would you please?
Sure. Lefkowitz.
Thank you.
I just wanted to talk as a member of the public As somebody who's
She's
like
saying-
watched this process. Oh,
Did you
sorry.
give your, sorry, did you give your address? And
Oh.
you live in the same house?
Yes.
Okay, good.
That's what I thought she said. Go ahead.
Um, yeah, so I wanted to just talk to you a little bit, just from my perspective as somebody who's a member of the community, as somebody who has seen this process from the beginning. Firstly, I've seen from the beginning, the countless hours of work that went into making this structure a reality in terms of, in front of the zoning board. There were many meetings, which resulted, like my mom said, in the alteration of the plans multiple times, many times, to make sure that the plans didn't just fall within the legal aspects of the law, but the spirit of the law. This was a phrase used by one of the zoning officers. And this is important because Highland Park's a beautiful town. And part of the reason for zoning laws is to make sure that we, respect the integrity of this town and we keep it as beautiful as it is. This was a very consuming process, a very rigorous process. And once the approvals were granted and the loans were sought out and the loans were taken, the fact that this process is capable of being paused for such a long period of time, because
How'd you know lawyers trying to pull out? I mean, just spotted it right away. The lawyer comes over and says, well, of course it's an accessory structure. You live in a house, you don't live in the pool. But as people picked up, garage has the same properties, which is you don't, I mean, most of us, I assume, don't live in a garage. Basically, I think the comparison to the garage, which people agree that if it's built part of the house, I haven't seen people taking them down. If they have a second floor or that part is not accessory structure. And the best of
right behind him right after he had his accident. And I've sat behind him during his whole recovery. And to this very day, I don't know if any of you are familiar that in the a shawl, and it's painful to watch him try to put on that show.
Leon Haller. B34, North Clifford Avenue. Farm.
You're represented by counsel, sir.
Well, I'm sweet though. Am I not?
Well, since you have an attorney who's entered an appearance in your behalf, it would be preferable if the attorney spoke in your
Mr. Howard, do you have anything you'd like to tell the board?
How's that?
Still not sufficient, but go ahead if you want. We're represented by counsel throughout this, so I don't understand why it would be, I object to it.
On that note, I've been living here for 30+ years.
Counselor, I would suggest that I think you can do this on behalf of your client.
I'd rather do it through question and answer of my clients, because my client would like to express his own opinion.
If you'd like to voir dire your client, that would be fine.
Sure, go ahead. So, Mr. Howard, is there anything that you'd like to tell the board?
Yeah.
What is it that you'd like to tell the board?
I'd like to tell the board that I'm probably living here as long as everybody on the board or longer, 33+ years. Longer my wife and children, we raised an entire family here. And the issue is really, how shall I say this? Obtrusive monstrosity. That's the correct words to start, okay? We've had a beautiful view up until now. Our sun would come, the sun would come out in the morning. We'd be able to look from our terrace, from our deck, and from our kitchen, and see the sun, and it was beautiful. And now, at 11, 12 o'clock, we finally get some rays. It's just incredible. The picture that here. This picture doesn't even show half of it, because you can see a sun here. This roof is completely normal. It's got roofing on it. And
Which was the firm, you took that photograph?
my Marine camera took that photograph.
That's fine. You operated the camera, that's fine. Please speak into the microphone.
Trying to. So the roof line on this particular part of this monstrosity is 29.5 feet high from what I understand. 29.5 feet, and the roof on the building is 33 to 35 feet, don't know exactly. The roof line is incredibly high. We tried to negotiate with them to bring it down, and every time there was another issue that they didn't want to bring it down. Medical reason, this reason, that reason, everything under the sun. They just want to be in our face. It's a horrible situation. We have laws to prevent this from happening, and people on the board evidently have the authority to make this happen. We want the roof brought down. We want the building to a normal size. An accessory structure, it is an accessory structure. There's a couple of reasons why. That my attorney might have not said. When this building was built, or is being built right now, an architect designed this building. And from what I understand from everything that I've heard from court, is that an engineer designed this building, and an architect designed this building. And an engineer is not supposed to design a building other than for an accessory structure. Now, I don't know why my attorney would mention it, probably get to it, it was probably shut down a few times by the board attorney here. But this is the fact, okay? This is an accessory building. The judge ruled it's an accessory building. It's too big. It's supposed to be accessory is 600 feet, 15 feet high maximum. This building is bigger than a lot of the homes in Highland Park. It's 1,050 feet and 29 feet high. It's absolutely insane to build something that size. You wanted a pool, it should have been smaller. It should have been conforming with other people's needs and other people that live in the area as well. Again, I'm gonna bring up the winterizing thing because they let the building rot the entire winter. I don't know why, you don't know why, they probably don't know why, I don't know. But they started doing it a couple of weeks ago, and again, they defied the judge's order. The judge said, winterize the building, don't add any structure to it. They built out the whole front of it, and we're going to court again on July 2nd to try to take that piece of the structure down, because they're doing everything, they're pushing the envelope on us. They're trying to destroy us monetarily, and they're trying to destroy us our real estate value. I mean, I don't know if it matters to anybody else here, but real estate value in Highland Park is fair, not great, fair. And they're trying to destroy my investment, my real estate, by building their investment and their real estate. Totally uncalled for and not necessary. A few more minutes. The biggest problem here is that I approached that man, okay, and I asked him for a plot plan. He says, in quotes, I'm not giving you my plans, go to the zoning board and get the plans, okay? That was the beginning of the end, because he didn't allow us, he didn't want us to talk to us, he didn't want us to think about anything, to discuss anything with him, to make any arrangements that both sides are happy. Didn't want it, he just wiped me off, wiped me dry. So I went to the zoning board, the construction office, and I asked for the plans. And they said, well, you have to fill out a Oprah Pfizer, I forgot what it's. Okay, I filled it out. Open Public Records Act. Open Public Records Act, fine, I'm not filling it. And I filled it out, sent it in. It was denied, okay? I filled it out, I sent it in again, I was denied again. I had two friends fill it out, denied, why? Secret plans. What's the secret plans? I don't understand. Secret plans. My attorney tried to get the plans too. He was denied. How do you like that? He was denied as well. The only way we got the plans, he had to subpoena the plans. So there's something going on that this man didn't want us to see the plans before the building. So they can say all they want about, yeah, the Hallows are unfair, or we're not right, and all of this stuff. But the bottom line really is, they were deceptive. They were deceptive to us, they're deceptive to the court, they're deceptive to the judge. They try to push the envelope as much as they can by building things they're not supposed to. The judge put it in his order. If you build it and it's not supposed to be there, I'm gonna order it down. You didn't get to that point yet, that's July 2nd. We didn't get to that point, we're on our way. The board should be, this governing board should know, deception is what their motto is. I was on. Thank you. Thank you, I'd like to respond. First, correct. Can you please use the microphone? Yes. Identify yourself there, please. Yes, Peter Oliver, Council for the Highlands. First, I'd like to address the deception that was made for this evening. One involved the location of the fence. It was represented that the fence was within 10 feet
as I'm sure your professionals can attest, there's a 10-foot setback with regards to that fence. So it's at least more than 10 feet back. With regards to the comments that were made by Mr. Pollard, my client, Mr. Rabayev, would like to address those. And as Mr. Rabayev got to speak, I'm going to request that the board hear Mr. Rabayev out to address Mr. Pollard's comments.
That would be fine. I think I would have to know, I think that the comment should be,
You're going to keep them brief.
yes. Let me swear you in, sir. Thank you. You solemnly swear that the testimony you're about to give in this matter will be the truth, so help you God. Please state your name and spell your last name for the record.
Elisei Revive, equals from Alex, last name is Ratavd.
Very good. Would you like your attorney with you, just in case there's any questions?
I don't much that.
All right.
My wife already mentioned. I just want to correct some of the mischaracterizations that were implied in some statements, that they're actually not true. First and foremost, we went to all our neighbors and we informed them before we started building that, look, by the way, my wife didn't mention this, we've lived in Highland Park for almost 2 decades. We've also raised our family here. We love the town and that's where we wanted to stay. I think it's a side point, but it's not only college to be here and raise our families here. But before we started building, we went to all the neighbors, including the towers, and we told them, look, we're about to start building. If you have any questions, comments, or anything else like that, let's just discuss that and we have to address them. To the point where there was a question, there was a tree on Haller's property if he wanted me to take down, and I paid for taking it down, he also wanted it down. And we've communicated about that, and there was no issues with communication. So to say that we were not approachable or we didn't, when he asked me, can I see your house plans? I thought it was intrusive, and what I said to him, I do think it reaches some modesty for me to show you my plans. Now they're displayed for everyone to see, of course, we passed that point, but I didn't want, like, why do you care where my master bedroom was? Why do you care where my windows are? Like, I'm working with the township to approve it. That's why I said this. That's really was the purpose and is still the purpose. And I'm very uncomfortable with this display in public of like private life and what the house looks like and whatnot. The other thing in terms of just not being amicable to make changes, we've sent them plans to actually show how we can lower the roof and exactly in the structure, which was bothering them with sunlight significantly to the most minimal level that it would just pop out like a foot or two from the bare minimum, so it's not flat. It's like really hard to make it flat, and I was willing to work with that. So the response back was, and I'm just quoting from memory, they asked me to plant 35-foot trees going in the peripheral of their household, which I don't know if you landscape it, but to plant a 35-foot tree, you need about 20-foot radius. Besides the economic expense, it's just not feasible on any side. They asked me to pay for all their attorney fees. They asked me to render all the plants everywhere. And this was like a list of 10 or 12 different demands that they end up having. Right? And the point is that the mischaracterization that I wasn't amicable, I didn't work with my neighbors, I did things in secrecy. As a matter of fact, I speak to my other neighbors all the time about what's happening, give them heads up. And it's just, I didn't want to share my plans, which I still fall to that decision. I wouldn't share my plans if I didn't have to with people that I don't live with. So that's really what it was. And I think for the board, I really have nothing else to say. Thank you so much.
Thank you. So is there any other member of the public? And please, could you please be so kind to make it keep brief?
Yeah. Oh, yes, absolutely.
State your name.
My name is Abraham Bodlander. I live at 134 North 10th Avenue in Highland Park. I happen to have been the next door neighbor of the Rabayevs for the past almost 20 years now. I don't claim to be an expert on understanding pictures, and if a pool is considered an accessory use, I don't know if that means that the building that it's in is also an accessory use. It looks like it's part of the rest of the house, but that's not why I'm here. You made that decision and you have the right, because that's what you do for a living, and we appreciate everything you do. But what I have to just speak to the character of my neighbors here. I've been enjoying being their neighbors for many, many years. Their house is slightly bigger than mine. Doesn't really bother me. We live very close to each other, and not having sunlight or whatever, that really hasn't affected it. We have a very good relationship, and I find them to be very good and trustworthy and generous and good members, upstanding members of the community, and to paint them as anything otherwise is personally offensive. I just wanted the court to hear that, and thank you for your time.
Thank you. Just for the record, it's a board of volunteers.
Okay, great. Thank you for your volunteers.
Yes, please come to the microphone and state your name. It's important because the meeting is recorded.
I'm Susan Handler, Leon's wife, and we live at 334 North Fifth Avenue. And here we are. Okay. I'm sorry that you had a terrible accident. And I wish you all the best in recovery and all of your whatever rehab that you have to do. I think appreciate it, okay? But I don't really think that has any bearing on the fact that we're building this. I get it that he needs to have rehabilitation, he needs to have access to a pool, but you know what, there are gyms around available for rehabilitation and for swimming and for fun. There have been many people in our neighborhood that have built pools, okay, for whatever reason, because they needed to run or whatever. The pools have been constructed in a way that wasn't obtrusive to the next door neighbors. Okay, there were several people here that have pools, okay, that did it in compliance with just being nice, okay? I don't think these pictures do justice to what this house looks like. As my husband said, we've been living in the neighborhood for many years. It might not mean anything. We were here, we were long neighbors for a long time, okay? We welcome our neighbors. I really couldn't care less if the Revives decided and got permission to build another floor onto their house. It's fine, okay? But this pool house, this accessory use disturbs our living, okay? And it makes it extremely uncomfortable. Now, I invite you all to come to my home for coffee or just to take a look at the structure and tell me or be honest and say, would you like to be looking at this every time you looked out on your deck? Okay, Highland Park is a beautiful area, okay, and I don't know, we bought this property from this woman who apparently owned 3/4 of Highland Park, and we live in unison with all of our neighbors. We don't have a problem. We might have had some issues here and there, but we worked it out. No one has ever built a structure like this, close to this, on our properties. So if anybody would like to come and see it, visually see it, I ask you to do it, and then you would see really what we're talking about. Now, the plans were not available to us, okay? Yes, Mr. Rabayev had called once and he said, oh, if you want to come and talk about it, my husband finally got back to him. Did not want to release the plans. Okay. I drove by one day, I was coming out of my house and I saw the Rabayevs going into the house and they were closing the gates. And I think they had the company, they were showing some of the structure to their company. And I'm thinking to myself, should I go out of the car or whatever? And I said, okay, I'm just gonna address Mrs. Gold, okay? Because maybe we will be neighbors one day, and I don't want this to continue to affect our relationship. And I said to her, in what world do you think, because the wall of the pool house had just gone up, okay? And I was just like, I couldn't believe it. As I said to her, in what world do you think this is right to do to a neighbor? Seeing that we all live together and all of our neighbors are close, to build this huge structure and totally block out your neighbors to the right. And it's just like, I'm moving in, I don't care what I do, doesn't matter, that whole thing is going. You know what she said to me? We come from Brooklyn. She said, we come from Brooklyn, and in Brooklyn, that's the way they do things, okay? And not too long afterwards, the roof of that house went up, and I don't know, what is it, about 15 feet? No, the roof. The pool roof is 29 feet, they added to the height of the wall. Now, that was no consideration, not at all, okay? And it just continues to go up and obstruct everything. It obstructs the calm of the neighborhood. I think that my neighbors could see it from a mile away. It's a little ridiculous. Okay, so I'm here just to say that I know you had objections, and maybe you've all had objections to some of these things, but really, I would like you to come and see if that's within the bounds of, to come and see what this structure looks like. And again, I wish the Revives all the health and the ability to heal, okay? But it's not really a part of what we're talking about. This should not be a pool structure that obstructs everything because he needs to do rehab. Again, if they've constructed it in their house, they could have put a bubble on it, like so many other people have, okay? And it could have been an all-year thing. Why is this? Because, and then they put garage doors on the other side of it so that it should literally be indoor and outdoor, winter and summer, okay? And honestly, it wouldn't make much of a difference to me. Okay, whether they had a pool or not, they could have a pool, it's nice, like my husband said, actually, in court, we were hopeful that we would be good neighbors, that they'd invite us over to swim, okay, but that's not gonna happen. Anyway, that's what I have to say, and I hope that you all on the board will look kindly on both sides, and you can understand why we are objecting to this, not because we're bad people, not because we don't want them to have nice things, not because our house is bigger or your house is bigger, but just we wanted to be friendly neighbors, and they made it impossible. So, thank you.
Thank you so much.
Should you put this back there?
So would it be super brief if you want to make a statement? I'm not think that the village has been better. You use the microphone?
Yes. My name is John Shavai. She's that house. 149 North Fifth Avenue.
Sorry, I can't hear. Could you speak up just a little bit, sir?
My name is John Shavai, and my wife recently purchased a house, North Fifth Avenue. At 149 North Fifth Avenue. And we are. It's very sad to see that house is not very young. With construction. It's a beautiful house with realtor always told us that you have to fly for the nice and beautiful house. House and development. That's what we drove off the town, you see beautiful houses. We made a decision. I think we'd love to see the how to proceed with construction. Have opportunity.
Thank you. Thank you so much. Don't see who you are.
Citizens of public, I have a big question of the meeting, right? Let me do a final. Okay, I'm in the motion, those, motion.
I'll second.
If you roll call. Yeah, and I would say, yeah, was,
Yeah.
yes.
So, is it safe to assume, because you meet this application as a people for the board, that the house is built in conformance with all of the setbacks, side yard, impervious coverage, all that?
Chris, can you answer that?
I think the answer is presumably yes, because if you see the zoning permit, construction permit, all the board is asked is to make an interpretation of the zoning ordinance.
Sorry, the impervious coverage is not correct. There are, I think, 43%.
The public, sir, so the public portion of the meeting is closed.
As I said, what's being requested of the board is to make an interpretation of the ordinance.
All right, then I have another question. I just want to be clear as to the process, right? So we render our opinion tonight, and then is that it's done, or if our opinion goes to the judge and then the judge revisits?
No, this would not necessarily go to the judge. This is particular to this use, this application. These are separate, these are on separate tracks.
But there are two tracks.
I would say so, yes. I mean, I think there's been some confusion introduced into the proceeding by saying that, you know, whatever decision the board makes may be contrary to what the court has already decided. This board has inherent authority under section 70B of the municipal land use law to make a determination as to an interpretation. And it is doing that now. What it is doing is perfectly legal. So if the board determines that it believes that the pool house or pool, you know, covered pool is not an accessory use, that's certainly within its authority. If it decides it's going to determine elsewhere, otherwise, that is also within its authority.
Another question. Is it possible we can no interpretation at all?
I think we should, at least in front of the board, is the request by the applicant to make a decision either way.
Mr. Gibbons, would it be accurate to say the board has been asked to make an interpretation on the provision in the ordinance, and the board is taking action by resolution? Effectively, that's the end of the board's interaction with the elected.
Correct. Correct. If the board elected not to act, I don't believe that would be really called for. The board would make a decision under section 70B. The board either has to determine that it makes the interpretation as to whether it is or it isn't, if you will. And that's really what the board must do. The board can't punt.
Okay.
And
question. No, that's just an honest question. So we do have two choices to make an interpretation saying that the.
Yes, the board has the right to make the interpretation. As I said, it doesn't have the authority to punt, saying, no, we're not gonna think any.
So are you waiting for, do we need a motion to vote on?
Yes, we need first that thing, yes, so, yes, we need to make a motion in terms of the resolution that we would do, and then we have the discussion.
I have another question. Chris, you mentioned that we should bear in mind, I thought you were gonna say something about home housing.
we discussed before, that's going through the hypothetical questions. So I can summarize later.
Chris, I'm not totally if I'm correct, but the rules for an accessory use, they were basically put in place to keep people from putting small apartments like above their garages, back of their property.
So I didn't write that one, that's what my colleague at LRK did. The legislative intent of that ordinance amendment, which I believe is back in 2020. was to add more flexibility for people to use detached garages for all workspaces, including home occupations. Those strictly related to that issue. Right. I did have a question for Mr. Gibbons.
Yes.
Related to when the board enters in or renders an opinion or interpretation about this particular topic. This interpretation will impact not just this property, but how accessory structures and principal structures are regulated around the entire community. Right?
No, in my opinion, we're not. Each application stands on its own merits.
Okay, so just.
And to claim that there would be some kind of precedent, that's not the way to law.
Thank you.
So I believe our discussion will be about the most, like what is the look in the front, and you need to play with the resolution to be interpretation that the building question is this element or the part of the.
I believe, I mean, is there any summation from the applicant's attorney?
The interpretation is whether or not it's an accessory structure or not under.
Right, so whether or not it's an accessory structure as indicated in our ordinance.
You have to vote yes or no, yes, and accessory structure or no. So that would be one.
Do we have to vote tonight?
You don't have to, but in terms of be very preferably, at least.
Well, my potential or my rationale is that some of these zoning regulations or whatever they call them haven't been completely presented to us. Like, for example, the situation with the swimming pool and accessory use, that it wasn't, it didn't just say swimming pool, it had a whole list of other things, for example. So there's parts of the statute that haven't been reviewed by all of us, which may be important for the interpretation of this structure. I'm making sense or not.
I'm not sure I understand what you're.
We've been presented with snippets of the zoning regulations. We haven't been presented with the entire regulation. And I think that maybe that, having the whole thing in context would allow us to understand what a main purpose or the building principle versus the accessory building or use.
Well, there are the questions that you have for the municipal planner. I think that's very important. If you just indicated that you may not, that you perhaps there are questions that need to be answered, so I defer to him. Yes, sir.
I actually gonna request that I believe Chris put together his thoughts on this. And that's been distributed to the board. That's it would be helpful for him to lead that to the board of what our professional, what the borough's professionals think about this matter or said about that.
Well, what he has prepared is a matter of record, just as it is with the other materials that were received from both sides, but if you want to give a comprehensive summary on the records yourself, I see, yes, probably briefly, I mean, I think that would be appropriate.
I suppose before I do that summation.
Speak up a little bit, sir.
Before I do that summation, Mr. Gibbons, would it be appropriate for me to describe the legislative intent of an ordinance, even notwithstanding the literal reading of ordinance?
Yes, I believe that, especially since you were involved, if I recall, your firm was involved in preparation of that ordinance.
Yes.
So I would say the answer is yes, you can do that.
Yes, so we're referring to what we categorize as the residential form-based code, starting at section 230-149.1 through 6, as well as graphic representations as to what would be appropriate regulations and adopted regulations for the design of single-family dwellings. In that ordinance, we did address accessory structures, and there was a comment regarding the limitation of the accessory structure being limited to 600 square feet in conjunction with a single and two-family dwelling. That legislative intent was that if there is an accessory structure on a property for a single two-family dwelling, it is limited to 600 square feet to avoid a situation where accessory structure may have been larger than a house in the case of less than 600 square feet. There was no such restriction for a commercial property. That is why it was written down. That was a legislative. With regard to the definition of accessory building and use, I will admit it is not clear. I did not write that ordinance. It's probably been in place for the last 30 or 40 years. I can attest though, when I did do the adoption, separation of the ordinance and assisted with the adoption of the residential form-based code, which includes section 230-149.25 regarding accessory structures. We did not intend to basically do housekeeping for the rest of the ordinance. That would be a very expensive project that would need to be authorized by the council, because the ordinance does need nothing. And the other reason for that is because it was inferred and commonly used throughout the many years I've been here in Highland Park. I've also been in Kentucky as well, but in Highland Park, it's commonly known and inferred throughout the ordinance that if a structure is detached from the principal structure, it is an accessory building. It does not preclude accessory uses from being inside the principal building, as a board member mentioned. So with that being said, describing both working with the Borough of Highland Park and updating its ordinances, there's much work to be done. But I rendered a report dated June 22nd, 2026, given my opinion. This does not substitute as your interpretation, as the power is in your hands. But my opinion is that the pool structure is, the pool enclosure is connected to the main portion of the dwelling by an interior hallway that opens to the family room. There's interior doors, but no exterior doors for egress other than garage doors or folding doors in this case. The structure, the pool enclosure has the same building foundation system, although it's different subsections. Some are slabs, some are structured differently. But more importantly, it shares the same roof structure. So it gives the appearance of the attached structure from the outside. But in terms of floor plan, it certainly is part of the main structure by virtue of the connecting hallway, connecting the structures. And as depicted on the plans, the pool enclosure is not a separate structure in the lot. There's no separation. Even if there was 1 inch of separation, I would classify that, in my opinion, I'll classify as a detached structure. However, since it was designed as part of the structure, main structure is the whole structure, including pool enclosure, in my opinion, constitutes the principal building. I already discussed that. The fact that the structure encloses a swimming pool does not alter my interpretation. Again, ordinance anticipates that there will be accessory uses inside principal buildings, separating uses from buildings. And that does not confine them. Furthermore, the ordinance does not confine accessory uses inside accessory buildings, as reflected in the treatment of home occupations, private garages, private swimming pools, home gyms, and so on and so forth. The question, therefore, is really the question that's being asked is about the structure itself. And based on the plans that are submitted for our ability to determine whether the structure, whether the accessory structure is my opinion that the pool enclosure as depicted on the plans constitutes part of the principal building and is therefore subject to the bulk setback regulations applicable to principal buildings in accordance with 230-149 ordinance. If the pool structure was detached from the rest of the main building, then it will be subject to an accessory structure setback, subject to the regulations of 230-149.5.
Thank you. Is this a time to make a motion? Is it time now to make a motion?
Yes.
I'd like to offer a motion. I'd appreciate council's comment if it's well formulated. I would move that the board interpret the relevant provisions of the borough ordinance to determine that the indoor pool enclosure, bathroom, and connecting hallway, by virtue of their shared continuous foundation, unified roof framing, and interior circulation, constitute an integrated wing of the principal building rather than a separate or attached accessory building.
I think that's well crafted, yes. I think it certainly can be considered as a motion.
I'll second that motion.
So do we have a discussion on the motion? Any comments that any board member may have? Or questions or
any questions?
Thoughts that you want to share?
I found Chris's testimony compelling as well as Mr. Longo's. This is lots of information remains a question we have to look at.
So yes.
So we, just for the board, it's not for us to decide if this is a big building or not, it's a question, because that is within the zoning that we have, and actually I look back into the zoning, I thought, these are enormous buildings that are possible at that place. But that's not our question. But and when you go through the neighborhood, this is really really big buildings. So our question is this an accessory, so I would never know the question. Is this an independent building by itself, or is it part of the main structure? Right? And that's the question, and your wording is on the record, and where we agree with that, with the yes vote, or find that for the no. Right?
Yes, agree would be a yes vote that you will interpret it as you would put it an integrated structure and not an accessory structure. So a vote in favor would be that. A vote against it would be that you don't agree with that.
Yeah.
By implication, I presume that would be an accessory structure.
Okay, are we ready to make a vote? If the vote happens.
Mr. Fector,
Yes.
Mr. Pheasant,
Yes.
Mr. Hosapper,
Yes.
Ms. Corbin,
Yes.
Mr. Winfrey,
Yes.
Mr. Holford,
Yes.
Mr. Dickerson,
Yes.
Mr. Bonnie.
Yes.
Thank you, that motion is approved. Thank you so much. We have more business to do at the board. Yes, please.
I believe at the next meeting, we're preparing a resolution.
I would believe that I will prepare a resolution, yes, either myself or Mr. Thomas will, but I expect that, when is the next meeting?
July 27th.
The 27th? I believe that it'll be ready for that time.
I think, question I have, this is really not a jurisdiction report, but understanding that they believe there's a court hearing July 2nd. If
There is. There's a court hearing July 2nd. If there's any way to expedite the resolution, as I mentioned before, any decisions for it to aid the court, it's not an overruling of the court, you just aid the court system.
So I don't believe we can simply expedite the resolution because the board would have need to do that.
Right, well, the decision is of record. The form and content of the resolution has to be approved by the board.
Right.
So, I mean, the way one would address that to the court, if that was an issue, is simply to say, I know this is what I would do, is, and I've done many of these, to indicate that the board has made this decision, the resolution is pending.
Thank you.
Exactly, majority of experience, I would think members of the judiciary would understand that. I see no reason. The Brunswick or Middlesex County has always had a fine judiciary in terms of land use matters and prerogative matters, so I presume they will understand that well.
Thank you. That was education I needed.
I apologize.
That was the education I needed. I want to understand that.
All right.
In the process.
Oh, okay, thank you. The board has more business to do, so if a member of the public wants to leave. We're gonna still have some. It's still very good.
Yes. Oh, Mr. Dickerson, you think you could sign this so I can notarize it?
So we, as a board, we still have to prove the minutes from the previous meetings. Thank you for putting them together. We all had a chance to review them. So I make, does anybody make a motion to approve the minutes? Yeah. Or any questions about the minutes? Does anybody make a motion?
I will make a motion to approve the minutes.
We second it.
Second.
Thank you. Who was the, roll call?
Mr. Becker,
Yes.
Mr. Pheasant,
Yes.
Mr. Malzahn.
Yes.
Ms. Corbin,
Yes.
Mr. Winfrey,
Yes.
Mr. Hoffer,
Yes.
Mr. Dickinson,
I was not present at that meeting.
Same,
Yeah.
Mr. Bonnie,
Yes.
Thank you. So my last business, and you can do this, if you'll bear with me for the few, like 2 more minutes, is to say, our board attorney provided us with the update of the rules and regulations of the zoning board that we all have as the last print of the file. And basically what it's saying is, what we said in the beginning, that anybody, because you're Zoom now always on, and so that basically what it's saying, that in virtual format, you have something to contribute to the application, you need to be here. You can listen to it from home, you can say whatever you want from it, but anything that is relevant for the application has to be front home. And that is what this edition is saying. So we had a chance to look at it, and I will, if anybody has a question for it, you have it there, the changes are marked and red. Do you need to think about it for the, make a vote? Okay, so we can push it to the next. Okay, great. You can do that. All right.
The people make public comment have to be residents of Highland Park.
Not necessarily because of the public portion is the public in general. So I intend to be pretty open-minded with that. I mean, if it's a different situation where, for example, if it's an application for an actual approval, I mean, I tend to be fairly open-minded. Okay, well, this would be a problem. Yes. So what we actually need to do, it's got told what we need to do, we need to push the vote on the rules and regulation to the next meeting. We have to say aye in order to push it. Well, we go to the meeting from that, yeah. Aye, we'll go to airphones. So that. Some people.
So I make a motion to put the rules and regulations. I vote on the rules and regulations for the next meeting.
I said, you say, yeah. All in favor?
Aye.
All right, so then. We need to.
Motion to adjourn.
I think you can just do it. I can just do it, I can just do that. Okay, the meeting's adjourned.
All right.